My name is Keith Cooper. I'm the vice chair of the Beverly Hill Bar Association's Entertainment Law section. And quick note, kind of a housekeeping note, the Entertainment Law section is sponsored by Lawyers Mutual Insurance Company. And a little bit about them: for 5 decades, Lawyers Mutual has been the only California-based company to continuously provide lawyers through the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that they are directed by a group of dedicated lawyers. They offer special rates and competitive premiums for a wide range of areas of practice, including entertainment law. You can learn more at lawyersmutual.com. And what I often do, just because I think it's a cool feature, is I throw this in addition to my little scripted blurb there, is the fact that they do have kind of an ethics hotline. It's very, very handy to use, as opposed to, I think the California State Bar offers one as well. But if you're a member of Lawyers Mutual Insurance Company, it's very nice. You can call up if you have an ethical question or quandary. They will take the time to provide some guidance to you, answer that. And that's the nice thing about an insurance company run by lawyers. They can help you out in that regard. Cool feature, so I always like to mention it. Meantime, I'm delighted to introduce our speakers, Ryan Wedell and David Shraga. Ryan Wedell is a senior associate in the Entertainment Technology and Advertising Practice Group at Sheppard Mullin in their Century City office, where his practice focuses on transactional matters in television, film, new media. He has deep expertise in scripted development and production, independent film finance, branded content, and Hollywood Guild regulations. He began his career as production counsel on Yellowstone and has since served as a go-to production lawyer on a range of acclaimed projects, including The Summer I Turned Pretty, Monarch, Legacy of Monsters, Pachinko, Mayor of Kingstown, and Lioness, among others. He was named to Variety's Hollywood New Leaders in 2023, received his JD from UCLA School of Law and his BA with high distinction from UC Berkeley. David Shraga, who first I want to note is also the secretary of the Entertainment Law section. He is a mediator at Signature Resolution and specializes in entertainment media and intellectual property. He has additional experience in complex business and employment litigation, has more than 20 years of legal experience in Los Angeles. His background includes work both as an entertainment and IP litigator and a senior in-house executive at Miramax and NBC Universal, where he developed deep expertise across film, television, and streaming. And with that, I'm going to turn it over to David and Ryan, and everybody enjoy the presentation.
Great. Well, thank you so much, Keith, for that gracious introduction. And Ryan, it's fantastic to be here with you today. Thanks for putting on this presentation for our membership. Really great to be talking to you.
Yeah, it's wonderful to be here as well. Thank you, Keith, for the intros. And David, it's always a pleasure. So let's get started. I can go ahead and set the stage here. So today we're going to be talking about SAG-AFTRA in particular, the Performers Union, and their new deal with the AMPTP for film and television content.
Fantastic. And I guess maybe you could sort of give us the big picture, for those members of our audience who are not labor experts like yourself, sort of what the big landscape is. And obviously, when we were here 3 years ago, we're in a very different environment. There were very contentious strikes involving the WGA and SAG. And now, obviously, we're in a place where the WGA has already made their agreement. SAG followed shortly thereafter, and it was just announced this past week that the DGA has reached an agreement with the AMPTP. So why is this year different, and what's the big picture?
Yeah, so it's quite a stark change from where we were 3 years ago, where we had over 100-day strikes for each of SAG-AFTRA and the WGA. I think part of the answer is just the normal negotiating cycle and how this works. It's very unusual for there to be consecutive strikes in a row. You'd have to look back to the 1980s to see activity like that. So when there is a strike, a lot of big picture issues get resolved. And that's certainly what happened here in 2023. Of course, there was a lot of pain involved in the recent strike, and I think that was on everyone's minds. And it didn't seem like there was an appetite around the industry for another strike. And also, there was new leadership at hand, both on the AMPTP side and on the Guild side. There were new presidents of the AMPTP, Greg Hessinger, and of SAG-AFTRA in particular, Sean Astin, who did note that Greg was helping to reset the relationship. And I think that's what all of the guilds and the producers were looking to do after the last strike and in the wake of, runaway productions and general industry contraction.
Yeah, what a difference a few years makes, but it really also demonstrates sort of the interrelatedness and interconnectivity between the major platforms and the unions in this city that we all work in as well. So maybe we can sort of jump into sort of the basics, right? Top level, what are we talking about when we get into a deal like this? We're always thinking about things like wage increases, pension, health, and welfare benefits. I know that was a big part of that the WGA was talking about in this latest cycle. What's the big picture on these top level terms that have been agreed?
Yeah, absolutely. So first and foremost, it's a 4-year deal. So just like the WGA, we're looking at a 4-year deal compared to the typical 3-year deals that the AMPTP has with the guilds. So this one is going to be expiring in June 30th, 2030. So we're going to have a lot of time to work under this agreement. It gives the producers a lot of clarity and certainty and less disruption as we move forward. In terms of money, you're looking at 3% increases compounding per year, which is the standard increases that you would expect. Compare that to 2023, where it was a bit higher to account for inflation. And then on the pension and health front, of course, there was a lot of discussion around this issue with the WGA in particular, but also SAG had its fair share of concerns. And with the WGA, what we saw is the AMPTP made a large cash infusion, multiple hundreds of millions of dollars into these funds to help prop them up. Here, there was some reporting that perhaps the AMPTP made a contribution to the pension plan, but that was never definitively confirmed. And so what you're looking at here in terms of new terms are 1% increases to the health contribution rate. And that's going to be taking effect over the next couple months. And then a 1% increase to the pension contribution rate, which is going to be taking effect when the pension and retirement funds of SAG and AFTRA merge. And that was one of the big terms that came out of this too. That merger is targeted for January 1st, 2028. So keep your eyes on that. How SAG otherwise chose to address the pension and health issues was internally with their membership, increasing the earned eligibility thresholds for health and the vesting eligibility thresholds for pension so that members have to do a little bit more work each year in order to qualify.
Yes, we're really seeing a response to the realities of the business environment, right? The costs of healthcare going up, the importance of fully funding these entitlement plans as well, and everybody's sort of pitching in from all different sides, it sounds like, in order to contribute, including the membership.
Absolutely.
So let's while we're sort of going through the nitty-gritty here, let's talk about some of the nuts and bolts things that have changed for the reps and that producers are going to want to know about. We kind of hear this term of art within the guild context of the working rules. What's the concept to understand here, and what has changed?
Yeah, so with working rules, there's always a lot of changes each guild cycle. And it's a lot of little things, right? Like on-set designees for minors now. You need to have one if they're under 16 rather than just under 14. You need to notify actors if you're going to a place that doesn't have cell phone reception. So there's little small stuff like that producers need to be mindful of. Given the timing here, I'll focus on some of the bigger issues which came in the television department, specifically with guest performers first. So in the last bargaining cycle, this concept of modified deal performers and modified guest performers were introduced. And this was a category of guest performer who are a little bit higher level. Episodic guest performers paid around $15,000, $20,000, $25,000. And it was a way for the producers to address consecutive employment requirements so that they would have a certain number of working days and a certain production period based upon how many episodes those people were guaranteed. Now, it was a one-size-fits-all approach in 2023 with regards to who qualified and whether you met the thresholds. So now what's been introduced is a new half-hour threshold for these performers. So it's about 20% lower of a rate than the hour-long episodic rate. And so if you're making a half-hour television show, you can more easily slot into these rates as a producer and take advantage of these working rules. Now, as part of that, the Guild did say that they were re-emphasizing some of the importance of providing soft work windows to guest performers and ensuring that they can take other jobs. And so that was a big thing that they emphasized. There were these rules around providing them information up front about what their dates would be. Doesn't look like those were always adhered to. So the Guild really emphasized that that is the expectation going forward.
Yeah, this is always a really interesting perspective or issue from the producer side, right? Because a lot of this plays out and how the production departments are planning the shoots, knowing how many days they're going to have folks when they need them to appear, what the commitments are going to need to look like in terms of scheduling. So I think this is one that really is going to play out when it comes to that collaborative process between talent and producers as well.
Absolutely.
A couple other things, relocation allowances, right? There's some new things that are happening there, and big picture, right? A lot of these things that we're talking about at the highest end of the market aren't necessarily being negotiated or much of an issue. People are getting paid well beyond scale, but this is really sort of, these are issues that do address the heart of the membership, I think.
Absolutely. And when you're talking about relocation allowances, now we're shifting over to series regular performers. And what the Guild is looking at here is the runaway production issue. There are so many productions now that are being shot abroad that relocation allowances are becoming a real important issue for performers who are spending months and months on end outside of the country. Or outside of Los Angeles, even in other parts of the country. And so the change here is that for seasons of a project commencing principal photography after September 3rd, you can't prorate the relocation allowance, which is $5,000 a month is the minimum. You can't prorate that for partial months. So it's all or nothing, even if they're just there for 1 week of that month. There's no cap on the number of months, except if you're in an 18 plus episode season, which is very uncommon these days. So it used to be a 6-month cap that you could prorate per month. Both of those are gone for the benefit of the performers. And now for international relocation in particular, if the performer can find a lease and provide a lease for some location and accommodations they're happy with, then the producer must advance 2 months of the relocation fee prior to travel. That could have tax credit implications, of course, if you're intending to book those directly as the producer, so something to be mindful of. And then finally, each month that the performer is required to be away and how that's measured is based upon the dates that the producer gives the performer. So the producer must be very careful about giving dates that are too far out. And this goes back to that soft work window requirement. There's an enhanced requirement to provide dates up front. But if you provide dates that are too far out, you're going to be held to those dates for purposes of providing a relocation allowance.
These are real issues that have a practical effect on the talent as well, right? I mean, these are things that if they're not getting paid the relocation, it starts to cut into their compensation and changes the overall economic bargain for them. Okay, very helpful to know in terms of some practical considerations. A couple more practical things, and this is something that comes up in the negotiations a lot, and I think it's something that people who handle legal and BA are going to want to be conscious of. Now we're talking about series regular options and exclusivity. I know SPAN is part of this too, but maybe you can talk about what some of the changes are to how we need to think about options and exclusivity.
Absolutely. So there was a big change here in 2023 where the money breaks for options and exclusivity went up significantly. And money break meaning the point at which you can freely bargain on these issues. And so in 2023, the money breaks were 65 and 70 for half hour, 65,000 an episode for a half hour, or 70,000 an episode for an hour. Now those are going up just slightly to 70,000 for a half hour and 75,000 for an hour long episode. Those kick in the summer of 2027. So July 1st, 2027. So we've still got about a year to bargain under the existing money breaks. But what that means is that if a performer is under those money breaks, then you're subject to SAG minimum restrictions for options, meaning you've got 18 months from commencement of principal photography of the first episode of a season to then pick up the option for the next episode, for the next season, excuse me. There are extension rights built in, but there are also, if you exercise that option, delay fees, where if you don't start them in time, you've got to pay a delay fee. They could potentially terminate if you don't start compensating them soon enough. So for options, you've just got to hit a higher amount for the performer in order to freely bargain on that. And for exclusivity, it's the same concept where you've got to hit that 70 or 75, or else the performer is going to have more flexibility to take guest star roles, second position series regular roles, and there's going to be a conflict-free window you have to provide between seasons. On exclusivity, though, perhaps the biggest change was to the commercial exclusivity, which was those thresholds have not been touched in a while, and they've almost doubled now. And so in order to bargain for commercial exclusivity, you've got to be paying at least $20,000 or $30,000 an episode for half-hour or hour performers. And in order to get off-camera exclusivity, you have to be paying $25,000 or $35,000 an episode, depending on half-hour hour. And those are almost double the prior thresholds. And something to think about there, and I think the Guild is really recognizing that so many performers are making significant amounts of their income in branded content now, commercial short form content outside of long form. And so the Guild recognized that, and that was clearly an important area that they went after this bargaining cycle.
It's a great point. It really, again, reflects an evolution of the business. I mean, these issues constantly come up in negotiations. It's so important for the studios to know that they can get options on this talent. If the series is fortunate enough to get picked up for future seasons, they want people to come back and return. They want to make sure that they're available for their shows. These exclusivity windows are so important, but the push-pull obviously is that it's taken longer and longer to get these pickups, right? And it's not the same old broadcast, system that we were used to for so many years, where they were working constantly. So this is something that comes up in the legislature. You hear about it in the news a lot in terms of exclusivity. So I think, again, it shows really that these issues are forefront, and they're looking at a collaborative approach towards this. So I don't know if you want to mention SPAN, or if we want to get into the next topic as well. I mean, SPAN sounds like it's a similar big picture conversation or consideration.
Yeah, just quickly on SPAN. So for a series regular, in order to freely bargain for work and production time, when you're actually shooting the project, it was a previous threshold of at least $25,000 an episode. That's going up to $35,000 an episode now in July 1st, 2027. And just one thing in closing before we move on to the next topic, for these money breaks, something to think about when you're making these deals is the performer going to cross over these thresholds in the midst of these deals? And how do you contract to account for that? And also, if you're taking a residual advance, which we're going to talk about shortly, does that put you below these thresholds? Because if it does, then you're going to be subject to these enhanced rules.
So, I mean, the key takeaway is you want to be checking in with your labor lawyers about these terms when you're negotiating these deals to make sure you're not running afoul of these provisions. It can get very, very nuanced. So let's talk about residuals. What are the big changes we've seeing in terms of what was agreed? I think there's a couple of main topics here.
Yeah, so residuals, it's really, a lot of it is just fine tuning. As you'd expect, the focus is on streaming residuals. And so there was some incremental increases for streaming residuals, which are calculated on a fixed basis. And so some of the fixed thresholds that are used to calculate them, like compensation caps and things like that, were increased, so that performers are generally going to see higher residuals. There was the success the SVOD success bonus in 2023 that was introduced, which is based upon how much that project is viewed domestically, and if it's viewed enough, they get a 20%. If it's viewed based upon this calculation, they get another 100% of their SVOD fixed residual, and now that's been increased to 110%. So that's the type of incremental improvements you're seeing. Otherwise, on residuals, the main thing to take note of here is residual advances and the rules on that. So the SVOD success bonus that I just mentioned, that is something that can now not be advanced against. So that is always going to be fresh cash now paid to the performers.
If I could just interrupt. So when we're talking
Yeah.
about residual advances, this really comes up for the people in the trenches negotiating these deals, right? You're agreeing to an episodic fee for a performer, but you're agreeing that a certain amount of the residuals are going to be treated as an advance against that fee, right? So sort of there's a delay in them actually seeing the residual payment down the road. But that process has changed in terms of how that negotiation has to take place, is what we're going to get into, I think.
That's true. And so a couple of things to note here is one, the guild and the producers confirm that best practice is to disclose the residual advance at the deal stage. So, sometimes the deals will be negotiated and then you'll issue a long form, it'll have the residual advance. That's technically not appropriate. The residual advance should be specifically bargained for. And with respect to the amount of the residual advance, typically in the industry, it's about 10%. Although for guild purposes, as of July 1st, 2027, they have a 15% cap, and that 15% cap is going to be applicable if paid less than $80,000 per episode. Although a new rule is that even if you're paid more than $80,000 an episode, that 15% cap will always apply to the amount up to $80,000. So to the first $80,000, there's always going to be a 15% cap on that. So you can never fully buy out residuals.
And then, of course, you mentioned the SVOD success bonus can't be treated as an advance against residuals. I mean, they're important points, right? Because these are things that people have to get into and have the conversation about upfront. And I think it's important to keep that in mind, even though sometimes it can create some tension in the negotiations, but better to address it early on. Okay, so let's start talking about artificial intelligence. Okay, I think this is obviously an area of interest to so many folks. Big picture, I think it seems like we're seeing a refining of the rules. Maybe you could just set the stage here in terms of what the rules required last time. In 2023, obviously it was a completely new framework was put in place, and now that's being shaped a little bit.
Absolutely. So just big picture, what we're thinking about is a few different categories of restrictions. So you've got employment-based digital replicas. So those are replicas where the performer actually worked and rendered services on the project. You've got independently created digital replicas, which are based on a real life person, but that performer, did not actually work on the project. They just licensed the right to create a replica of themselves. You've got synthetic performers, which everyone knows now. That was the Tilly Norwood, the big topic going into these negotiations. Then you've got digital alterations as well. So there's limitations on how much you can alter someone's performance, even short of a replica. And then, of course, AI training. So those are the categories that we're thinking about here. And when you look at employment-based digital replicas to start, I think the big picture item here is there was really a lot of clarifications. And
for a second, last time around, you mentioned the four big categories, but the big issues were consent and compensation, right? If you're going to be creating these things, you need consent, you need to have compensation, and there's sort of a lot of gray areas that I think existed around this. And so, as we get into employment-based digital replicas, what has been agreed now?
That's a great point. And that's really the crux of what they were seeking to address here with employment-based digital replicas. So first of all, they've clarified that the performer doesn't have to be scanned. They don't have to physically participate in the creation of the employment-based digital replica in order for it to qualify for that. Because the technology now has advanced such that a producer may not need to scan. They may just be able to use a photograph or photography of the performer to create the replica. So they've clarified that physical participation is not required. Now, the big one here was the exception to consent as to usage. So under the 2023 agreement, you had to get clear and conspicuous consent with a reasonably specific description of what the usage would be of the replica. There was an exception to that, where if it remained substantially as scripted or performed, that you didn't need consent. Now, the Guild has clarified that substantially as scripted is measured based upon the script that was given to the performer on or before the date they performed. So subsequent changes in the script, even if legitimate, that were not provided to the performer in advance, could not be used as the barometer for whether a substantial change was made. So they've closed and clarified that point as well.
The issue here again is like you're working on a show, They're going to scan you for the show. There might be some type of AI usage that they anticipate. The concern for talent was always, well, I don't want them putting words in my mouth that are different from what I was intending to speak, right? So this really sort of addresses that potential concern. But there's also this other issue about the producer needs to have an articulable business reason when seeking consent for an employment-based digital replica. Maybe you can talk to us about that.
Absolutely. And so I think this goes hand in hand with the new custodial requirements too. So a producer can't just ask a performer to come in and scan for a replica without any reason to do so, right? Or at least now there is an ability on the performer and their representatives to turn the screws on the producer and say, well, what is your articulable business reason for asking me to scan? Because what the guild and performers are saying here is that these digital assets are very valuable. And so they shouldn't just be creating them willy-nilly. They should have a real reason and need to create them. And as part of that, part of the new rules are custodial requirements, where access to these files needs to be limited to people with legitimate business need. The producer needs to use good faith efforts to protect the security of that digital replica, kind of like what you see with nudity and simulated sex photography. Those types of requests are going to be seen now on these riders if they haven't already been. So
It really comes back to this broader issue of concern about exercising control and consent over how something is being used and making sure that the talent's likeness is being safeguarded in a way that will let. For independently created digital replicas, this is the second category we talked about. I'll just run through. There were a couple of quick updates here. There's some changes to the individual compensation rates that are available or that must be paid. There's also some changes to the residual structures that are in place. What's your perspective on the big takeaway here?
You've got to be paid now for independent digital replicas. There wasn't technically a requirement before under the guild, and now there's a minimum and a residual applicable. So you've got to be paid for these types of licenses.
These two same core concepts. So now let's get into synthetic performers. Obviously, there's been a big discussion about this. So what's been agreed since 2023 in the framework? How has that changed?
Yeah, so it's been an incremental but important change. So with synthetic performers, these are, they're not based on anyone's likeness. There's a lot of loose language where the producers are agreeing to a principle strongly favoring human performance. And it's really an intent-based rule. The language is that producers do not intend to use synthetics in a human role that would otherwise be performed by a human, except when they reasonably conclude that the synthetic brings significant additional value. So there's a lot to chew on there. There's a lot of ways in which that could be argued. But I think the big picture is that if the producer now is going to use a synthetic in a human role, right? So does a digital monster or something, or an alien or something like that count? Who knows? Then there's a formal process in place now where they have to notify the union, and there's a specific period to meet with the union, discuss the usage, remuneration, and if they don't agree, then the union can arbitrate that. So I think what you're seeing now is the rule being tightened up a little bit, and also the process being organized with clear timelines, ability to arbitrate. But what you're not seeing is a specific value ascribed to, well, if I go ahead and use it, what does that penalty look like? Is that just a day scale? Is that something else? So there's uncertainty there on the producers that are going to probably want, force them to negotiate on some of these things, because it's not clear what the rate is going to be for that if the union does seek to arbitrate it.
It's an interesting move in the relationship. Obviously, there's people out there who are going to say, I don't want to see these synthetic performers in any of these types of productions. But, it's not something that the union went after. I think there's an acceptance that this is part of the conversation now. And they really were focusing on, let's engage with the studios to make sure that human-centered work is the focus of what they're doing. And if there is going to be work involving this type of technology, we have to have a conversation about what that's going to look like and what the compensation will be. And this arbitration provision is something that's new that really has sort of gives it teeth, because the last time around it was a good faith negotiation requirement, but now we're talking about a real mechanism to agree to some numbers. And and it leaves room to sort of talk about what the right number should look like, I think, based on how the performer is being used in the production.
That's right, and I think that it wasn't quite the clear and fast rules that maybe some were expecting to come out of this negotiation, and so it just signals that I think both parties are still hesitant to agree to a rigid framework about what this should look like when all of this is still developing. But they will figure it out because you've got to meet with the guild every time you do this now. If it's a human role that would otherwise be covered by a human performer.
And we'll see where we are in 4 years, right, with the technology and the landscape. So let's jump into another area that takes up a lot of conversation in our dialogue in the context of litigation, in the context of licensing the studio assets, training, right? So what has been agreed in terms of studios using their library properties and other things they're developing in connection with AI, generative AI training?
Yeah, great question. And just quickly for our audience, we are almost at the finish line. I recognize we're a minute over. We'll probably be finished in the next few minutes. Training here. So yes, this was very similar to what the WGA got in their deal. Where it's a pretty narrow requirement. The rule is that if the producer grants a license to an unaffiliated third party to use a SAG governed performance to train a publicly facing AI model, and the producer is paid compensation for that license, then the producer must give notice to the union. And if the union requests, note that's different than synthetic, where a meeting is required. If the union requests here, they need to meet with the union to discuss the license and remuneration. So as you can see with this type of rule, if the studios have their own AI tool, then they wouldn't need to give the union notice, right? This is about unaffiliated third parties that have a public-facing AI tool. And so from the producer's perspective, they're saying, this is our IP. You can't tell us how to use our IP. And then this is the guild responding saying, okay, but if you're licensing it out to third parties, that's where we do start to have an interest, because then you start to think about residuals and the performers having a vested interest in how this is licensed and used. And so I think this is setting the stage still for what could be a future residual in connection with AI training. We'll see where they land with that in 4 years' time.
Well, it's fascinating. And of course, there's always the internal conversation about contractually what's being agreed to about these things and what's allowed as well. So with the last couple of minutes we have here, why don't we talk about another hot topic in the industry right now, which is verticals. I know most people think about verticals right now as something that's been, so popular in Southeast Asia and is now coming into the US. And we have all these new great companies that are out there doing this. Can you set the stage in terms of, are these typically guild covered productions? I know the studios are talking now about trying to get into this space as well. What's the landscape and what's been agreed to in context of verticals now?
Yeah, so it is guild covered work, and all the guilds have been very clear about that to their members, that this is guild covered work for which you must work with a signatory. Now, the problem is there's not a clear framework under the guilds to do this, though SAG has been the leader in this space in issuing what's called a promulgated agreement in late 2025 that producers can use, that is specifically tailored to the vertical space. That agreement has not been collectively bargained. And so if the producer does not fit into that for some reason, maybe the budget doesn't work, they don't fit within the parameters, then technically the guild's position is this should be an original made for new media production under the film and television agreement. Now that's trying to fit, a round peg into a square hole, so it doesn't quite work. And so what the guild has done here is, again, this is very loose, but they've basically said that if an AMPTP member company produces these projects on more than an experimental basis, then the union can request a meeting to discuss minimum terms and conditions. And if they can't agree, then the union can publicly advise their members on how to negotiate with the studio for that project. And so I think what you're seeing here is the guild saying, we want a collectively bargained agreement for these specific productions. And this is the process, kind of like AI training, where we're going to meet and we're going to continue to discuss And at some point, maybe even before 2030, there will be perhaps a collectively bargained agreement for this category of projects, because it could be in the producer's interest and in the performer's interest to have an agreement that is tailored to how these projects are produced and distributed.
Fantastic. That's a great overview of the vertical space. And I think, again, it really sort of reflects something great that happens within these union negotiations, which is we can spend part of this seminar talking about the nuts and bolts of traditional production and the realities of people going to work and relocating and how it affects people's lives. And then, of course, we can get into these forms of new media that are really changing the conversation about what needs to be agreed upon and the new technologies as well. Ryan, I don't know if you have any parting thoughts to share with us. I was just going to otherwise thank you for your expertise. Your background from Sheppard is so useful because you're always at the cutting edge of all these types of deals, working not only with the studios, but with so many producers. Any final takeaways for us?
Yeah, I think the final takeaway is that, I think both parties, the AMPTP and the Guild, are really focused on getting everyone back to work. And that's why these bargaining cycles were quick, efficient, and resulted in the outcomes that everyone wanted. And the Guild in particular is focused on how do we make sure that our performers have as much flexibility as possible, notice of their working dates, flexible exclusivity, defined option periods between seasons, right? Everyone is trying to work towards getting performers to work as much as possible and the producers to produce as much content, specifically here in the States, as possible.
Great. Well, I know everyone on this call loves seeing that as well. So with that, we'll say thank you again for sharing your expertise with us. It's been a fantastic seminar. I appreciate having this conversation with you.
Thank you, David. Appreciate you moderating and all of your valuable thoughts and ideas as well, and to everyone who attended.
Thanks, everyone.